So, Anna Maria Lundberg, the floor is yours. You will start the fourth day and on due diligence.
Thank you very much. I'm sorry I haven't been present before, but I have had some other important things to do, and I've been half sick. I've been teaching actually all the time, so I'm really sorry I couldn't be present. And Jukka here and Eleanor and Beate and in the research group, they have a great patience with me when I talk from a human rights perspective. I'm not into corporations actually or enterprises. I personally, this is not my, we can say my view, my stance on life. So it takes me some time actually to engage in the corporations or the rights holders' point of view in this business. I find myself that due diligence is an interesting concept and an very interesting exercise. However, in this field, when you're going through, I've been going through a lot of the more recent documents and a little bit past recent. You're an old person, so you think everything within the last 30 years is recent. But I mean, more of the documents in the field, you actually feel quite confused about the concepts used in some way, because international human rights law does not entirely coincide with the language that the UN guiding principles said. I mean, the first thing for us in a human rights-based approach is that we think you have the idea of respect, protect, and remedy in the guiding principles. But respect is the state, protect is the state, and respect is the corporate unit. Here we have in international human rights law, we divide the obligations somewhat different, because the obligations are of course due by the state. The state has obligations to regulate or to implement certain rights for those rights holders. And here we have that we have the protect, the state agencies themselves should not involve in human rights abuses, or they should see to that their own organs are not involved. And we have the notion of respect. They should stop other entities to be involved in human rights abuses. And there we will see a little bit later on the few documents from the human rights field I put up. There we see that the state obligations are limited by different international law rules. And then, of course, we have the fulfillment criteria, which is a criteria that comes in, I think, in the newer due diligence debate. So from a human rights perspective, we are a little bit at unease, but that was the basic thing of Kofi Annan, as I understand it, before the human rights, the UN guiding principles were accepted, is that we understood that the state wouldn't do enough. But still, in human rights law, we are to a large extent stuck with the state. So that is a little bit of a we can say an inconvenience still. So in some way, international human rights law could be said to be lagging behind this domain. because it will always relate to what can be acceptable as a state obligation, which is not always so easy to deal with in this domain. I will, in this, I will take up, of course, we can have different stakeholders or rights holders. In this presentation, and from my background myself, is that I want to emphasize the rights of indigenous peoples. And I think the rights of indigenous peoples have come forward more and more, particularly if we say, if we talk about it here in Norway, we have an ongoing conflict in the rule of law state of Norway. We have an ongoing conflict that actually the state does not want to implement a decision where actually the rights holders had their rights to enjoy their own culture violated. And it's since 2 years, it's called the Fosen case. Since 2 years, the state refuses to implement. The Supreme Court, or the highest court of the land, is telling us that this is a human rights violations of these people's cultural rights, but still we are trying to in some way negotiate or mitigate and see what the consequences are to this case. So indigenous people's rights are both a problem as well as a way, when you look at them, a way of understanding how human and an added value of the human rights approach, I would say. So wait a minute. And I'm sorry, I will change this lady here to another lady, or to a man. Actually, it was meant to be a man, but I couldn't really get it together. So human rights due diligence, as all of you know this. I have to go through these principles a little bit slowly by myself. Human rights due diligence process is to identify, prevent, mitigate, and account for how, wait a minute here. I'm trying to get lesser of these windows on my, it doesn't want to go on hiding. Oh, there I am. Okay, great. Now, so this human, we go back to the guiding principle to 2011, and then we're coming to this due diligence process to identify, prevent, mitigate, account for how they address their impacts on human rights, these companies. They should respect human rights. So how do we do this in the process? By referring to the international instruments. I will look at it a little bit later on here. If you look at the definitions, and we can look at the latest OECD 2023 revision of their guidelines, here we see a whole beautiful picture of what should be done. And what is, I think, is very important in this picture is that it's not said which ones should be prioritized, which rights should be prioritized in the system. But here we have in step 3, seize, prevent, or mitigate, or later on to provide for or cooperate in remediation. But particularly this seize is that certain things should cease immediately. And here I'm coming back to the Fosen wind case. It's very interesting that the windmills still are running. The energy production is ongoing, despite that actually the Supreme Court or the highest court, Høyesterett, have said that this is a human rights violation. So here we can see that even the state is not intending, and the companies involved are not intending to cease these activities. What I wanted to show you here. So when we are looking at this circle, how can we be informed and have a help from a human rights approach to due diligence? In the UN Declaration of Indigenous Peoples' Rights from 2007, this is a UN declaration which was adopted at a certain period of time within the UN framework. It's a non-binding document, but it's basically said to be endorsing or encapsulating the law as it stands at this time. There we have two very different, or a very important concept that is coming forward. That is in Article 19. We are talking about that states shall consult and cooperate in good faith with indigenous peoples concerned through their own representative institution in order to obtain their free, prior, and informed consent before adopting, implementing legislative other measures that may affect them. This affected that this free, prior, informed consent was actually already in part included in a binding legal document called within the International Labour Organization sphere. It was adopted by the International Labour Organization actually in the end of the 1980s. I happened to be at the International Labour Organization at that time, and it's very important for us when we are talking about stakeholder engagement, how many indigenous peoples that were involved in this process. However, if we're now looking at the text of this document, we can see that in Article 16, it's actually said something about with their free and informed consent. Not free, prior, and informed consent, but with their free and informed consent. So here we have this idea of the indigenous peoples actually having stakes in decision-making procedures. We see that sometimes you may end up in a situation that there are no consent that could be obtained, then there are other measures. Otherwise, this is within the field of relocation, as a field of indigenous people's rights being linked to the land or territory. Already in the convention, we have ILO Article 169, which talks about consultations. Why I'm mentioning this is that everybody, or it's said in many of the documents, that you should involve the stakeholders, meaningfully involve them. So how can we meaningfully involve them within the human rights sphere? On a human rights basis, we can see that some of the human rights legislation or normative documents tells us, at least in part, what should be done. So here we have both binding rules. These rules are binding only for, I think it is now 22 or 23 states that have ratified this convention. So it has a very low ratification. But if we look at the later document, the UN Declaration on Indigenous Peoples' Rights, we can see that that declaration has been endorsed by the state parties or by states several times, despite the fact that it was difficult to have it adopted. There were certain states, important states, that were not agreeing with its adoption. So here we have a move forward on these rights at the universal basis. Other rights that can actually help us in this in the due diligence process is, of course, the rights of the child. In the Convention of the Rights of the Child, we have certain articles which are giving us certain criteria for such a process. Children have the right to be heard and have their meaning actually taken into account according to Article 12. And they also have the right, they have the right to have that every decision is taken with the best interest of the child as a primary consideration, according to Article 3. So all decisions that are taking place should take place so that the outcome is in the best, at least it should be considered as a primary consideration, that their best interest should be at the forefront. So this gives us, of course, a interesting, but to a certain extent a little, or a not too much binding regulation on how to conduct a due diligence engagement. What I want to come to later on, since most of you are very familiar with these documents, but we can see, for example, that the new guidelines, OECD guidelines from 2023, take up certain things where they highlight the engagement of those rights holders or stakeholders. And they highlight, for example, the indigenous peoples, as well as, of course, human rights defenders, which are of a particular kind because they are more, if you have indigenous human rights defenders, all kind of research tells us that those are the people most at risk when big development projects take place. Actually, some international non-governmental organizations measure who have their actually life at stake at the most, and that is, generally speaking, indigenous human rights defenders. What has been discussed now, I just hope, because I think you know these documents. The drafting of the EU Corporate Sustainability Due Diligence Directive have been, it's considered because basically there are 3 versions from the Parliament, from 3 different EU institutions being discussed since this summer, or from the 8th of June this summer. The Danish Institute for Human Rights have made a commentary on these 3 drafts from this summer. And here I think it's very important to look at some of their recommendations for the future of this EU corporate sustainability due diligence directive. What has been we are now coming, I was talking mainly trying to refer to you, saying that our legally binding rules for human rights may not be developed in such a good way to respond to this process. So the binding, so therefore the Danish Center Institute for Human Rights actually takes an approach and trying to address the issue that if these binding rules come into place, if they are coming into place, we have to avoid limiting the more flexible approach which the normal due diligence approach gives us a possibility to, because here good companies they have more measures available and they can do more. So they are actually meeting certain criticism of this legislative to set these due diligence requirements in law, that it will actually limit what has been achieved by the dynamic development of the idea of a human rights and environmentally based due diligence process. So here the Danish Institute, and I think this is something which you most likely would be interested in discussing. Here they say about the substantive due diligence. What is required in order to undertake due diligence to the standard here is to have a sufficiently certain this directive should be sufficiently certain so the companies know what to do, and so the stakeholders are clear about what they can supervise. Because if we are coming into a situation where we have to define during the process what is what, it's not good. And that we can see, and that is perhaps one of the problems of legal certainty, is that you want legally clear rules. You don't. However, in the international human rights framework, state parties, they have a margin of appreciation on how to implement human rights. They can take different measures. The question is a little bit how this will be fitting in. So here they are talking about if we make lists of what is appropriate measures, then we may limit what was already achieved. So therefore, they are saying that the substantive due diligence obligation should encourage to the greatest extent possible a risk-based approach to due diligence, requiring to develop a program which are context-specific and designed to be effective. What they basically say is that you need to have examples and an open-ended. What they say of the extent of the due diligence obligation, there they are talking about the whole value chain and how value chains are trying to figure out how they are defined, but the whole value chain should be included, because otherwise you lose. If you don't get a hold of the end users, you may have very bad human rights consequences, which the company is not responsible for. The stakeholder engagement is also, they have some other headings also. I hope I have the, wait a minute. I don't have the, yes, I have the web page too. The stakeholders engagement, there we need to have a stakeholder identification process. Who are those stakeholders? And here we have in the different proposal from the Commission or the Parliament or the third body, now I can't recall, these three different, we have different ideas of stakeholders. So what they try to say is affected stakeholders should include individuals, groups, or communities whose rights or legitimate interests may be affected. They are normally talked about as rights holder in the OECD framework, also in the 2023 revision of the thing. And their legitimate representatives and credible experienced organizations working on the protection of the environment. So here we have stakeholders, but they will also include what is called vulnerable stakeholders, which is a subcategory that are particularly exposed to adverse impacts, such as indigenous peoples whose interests are in demand. So if we think about, if we go back to this due diligence circle or process, we need, if we have vulnerable stakeholders, they need to be involved in order to know which activities that should be seized or mitigated. So here it's very important the group of stakeholders actually involved in the process. What are they doing? Yeah, they should be involved. These stakeholders, particularly the rights holders, should be, they say, embedded. They should be involved at every stage of the process in order to properly identify the impacts and to determine appropriate measures, but also in proactive communication and the provision of relevant information. If you look at this proactive communication and the provision of relevant information, you see that that is extremely important. States shall consult and cooperate in good faith with indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent. If we don't have that full understanding of an exchange of information, then those stakeholders actually are ineffective in their participation. So I find the Danish Institute's comments of this new make somebody like me that has thought a long time ago that we absolutely needed legally binding regulation. The question is, one has to be careful when you draft regulation, of course, particularly at this stage. And here we have, I think, some reminders of what we need to think about in order to make to have good regulation. It may, here it is at the EU level, but it may also be at the national level. So, actually at this time, I think now I have used 20.
You have still a bit time,
yeah.
No problem here. So
yeah, because I would like to have a little bit, because I have a lot of these, I have a lot of documents I go through. We can go back a little bit. Is anybody of you studying human rights in this room? So do you know what I'm talking about when I'm talking about human rights regulations or conventions?
In general.
In general, okay. So in order for anybody involved in this to understand the human rights approach, we can go to of course, the binding regulation, the binding normative documents, which are different conventions. These conventions at the UN level, now I'm talking at the UN level, they are supervised or monitored by something called treaty bodies. These are treaty created organs and they speak to the states. The treaty-based organs, either they are in individual complaints procedure, they assess violations, or they try to, through a process of monitoring state compliance, they try to develop and tell the states what they actually need to do in order to, on a regular basis. This comes in periodically. And here we can have some help from something called general comments, which are actually aimed at the state only as the Committee on the Economic, Social and Cultural Rights says. The present general comment, which is on state obligations under the International Covenant of Economic, Social and Cultural Rights in the context of business activities. It is from 2017. These the private actors, including business entities, they are only indirectly aimed at by these documents. So we have to think about, we have to go around the states, and the states, like we have seen now, the Openness Transparency Act here, we have a German act, and as I only know about is a French act actually doing so. So we need to go around the states. States parties, though, may be held directly responsible because they don't see to protect. They can respect the right, but they don't protect the rights against other entities' infringement of them. So therefore, actually, the state is again of importance. There are very few of these general comments directly aimed at the business sector, due to the fact that they are mainly aimed at the state. However, we can see here that the general comment number 16, already from 2013, gave has a slightly different approach from this other general comment under another international convention, the Economic, Social and Cultural Rights, actually have a slightly different touch to it. And here you can see it, you can click on it. I have cut out parts of the general comment of the Economic, Social and Cultural Rights. Here we see, when I have referred to the ILO Convention, to the ILO Declaration, or no, not the ILO, the UN Declaration on the Rights of Indigenous Peoples, and now I'm talking about these two conventions. If you go back to the UN Guiding Principles in slightly after 2010, or they were, developed before that, in 2011, they actually point out that it's mainly the few core documents, the Universal Declaration and the Economic, Social and Cultural Rights Covenant and the Covenant on Civil and Political Rights, that are the important. I didn't take the Covenant on Civil and Political Rights. I didn't mention it because I wanted to be particular on indigenous peoples, but the Covenant on Civil and Political Rights have in its Article 27 a rule on the rights of persons belonging to minorities not to be denied their right to culture. This Article 27 was, so what I wanted to say with the UN Guiding Principles, now we have a broader range of human rights documents to inform us what human rights obligations, what human rights may entail, and who may be the stakeholders. The battery is is very low here on this machine. So article, why I want to actually conclude with a case on Norway again, referring back to the Fosen Wind case. The International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social and Cultural Rights, as well as the Convention on the Rights of the Child, plus the European Convention, plus the Convention on the Elimination of Discrimination Against Women. All of them are made into Norwegian law by an incorporation law, which took place in the end of the 1990s. So actually, when we come to the Fosen Wind case, we know that articles shall not be denied. This Fosen Wind case is about the building of green energy. It says the Supreme Court says that the expropriation decision and the concession decision are both violating Norwegian legal plus international standards in Article 27. That is said now very exactly 2 years ago. And nothing is done. This actually made me from the beginning thinking, but I thought that it's perhaps not so useful, made me actually from the beginning saying, because it's businesses doing it, of course. And just the other week on the TV, the Sami, not the Sami state called exactly those Sami up in the Fosen place, but other Sami were protesting against the non-implementation, and they went to Statkraft, also involved in this business. And Statkraft went out on the Norwegian national television and said, we should have listened to the Sami. This the boss of the Statkraft said when the Sami people were laying at them. Yes, 2 years later, nothing still happened. So what I wanted to say, perhaps in a kind of a not so positive note in the end, is that one of the things I thought about is to give you an article on the effectiveness of human rights due diligence for preventing business human rights abuses. I mean, here it's a statement. The Statkraft actually excused themselves and said we should have listened, but now done is done. So with this not so positive note, I would like to end, and I'm open. I have a lot of slides. I'm open for discussion. Thank you.
Thank you, Maria. Now I will stop recording and we go to discussion.